Hello and welcome to our webinar, Employee Classification and Overtime, clarifying the rules, regulations, and risk. You can tell I'm probably a little World Cup'd out today or something, I don't know. Anyway, my name is Julie Dorr and I will be your moderator for today's event. Our presentation will last approximately 40 minutes with the remaining time available for your questions. If during the presentation you have any questions at all, feel free to type them in that designated section to the right. It actually says questions on it, and we'll hold them and answer them at the end of the webinar during our Q&A session. We've got a big crowd on today, so we won't be able to handle questions during the course of the actual presentation. Earlier this morning, we emailed you a link to a copy of our presentation. If you haven't received it yet, feel free to email me right now at julie@thedoorgroup.com, and I'll send that document to you right away. And then before we get started, please note that this webinar and all the other accompanying materials are protected by copyright and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with legal counsel to address your specific situation. So let's get started today. We're going to welcome our expert panel. First, we have Linda Duffy. She's the president of Ethos Human Capital Solutions. Linda works with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. We also have our attorney, Marla Merhab Robinson. Marla's with the law firm Merhab Robinson Jackson and Clarkson, where she is partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. Marla is going to start us off today, so Marla, I'm going to turn it over to you.
Well, actually, another World Cup mistake. Linda's going to start us off today.
I am making World Cup mistakes today.
That's okay. We still love you. Hi, everyone. Thank you so much for joining us today. As Julie said, we appreciate you being here, and we do have a large group. So we're going to go over what we think is some very important information regarding exempt and non-exempt status and how to impact overtime, and especially with the minimum wage change coming into effect in California next week. All of this is sort of related. So you can see on the screen our agenda. I'm going to go just through an overview and why some of these issues are so important. Marla is going to walk us through the three big exemptions that everybody really takes a look at, which are the professional, executive, and administrative. Then I'm going to come back on and talk about salespeople and computer professionals. There are also important exemptions, but not used quite as much as the other three. We'll talk about just the liability if you don't, aren't in compliance with this, and then also what to do when you have to change an employee status one way or the other, from exempt to non-exempt or non-exempt to exempt. Go over some common questions that we get asked, and then we will definitely leave time to answer other questions that we don't address throughout the presentation. So again, we'll get started by just sort of talking about why this is so important. This is one of the most highly litigated and areas that both state and federal government take a look at. It can be so expensive to employers who get it wrong because there is such a potential for fines, and also the back pay can go back. It can look back at either 3 or 4 years depending on different factors. So if you misclassify an employee, it's not just an issue, a one-time thing. It can also result in a class action suit, and it's going to get expensive really quickly just on the fines and the back pay, penalties, things like that. Not to mention, you're going to be ended up hiring an employment attorney to help you defend yourself. So it's just so important that we get this correct up front. Now, when we talk about exempt versus non-exempt, just want to make sure we're all using the same lingo here. A lot of times I have clients that talk about hourly versus salary, and that's not really what we're talking about. You can pay people differently, and we'll talk about that in a second, but really what we're talking about is whether or not they are exempt under the overtime laws. And so if they are non-exempt, that means they are not exempt from the overtime laws, which means you have to pay them overtime. And so usually what happens is, if you look on the left-hand column here, here are some common factors having to do with non-exempt. You're paying them for all hours worked. You're actually keeping track of their time. And federal government, you have to pay more than 40 hours in a week. In the beautiful state of California, we also have a daily overtime provision. We're one of only like 5 industrialized states like that. So we have a daily overtime provision as well. So we have to pay overtime anything over 8 hours in a day or 40 hours in a week. We have meal and break rules. We're recording time. Compare that with people who are exempt under one of the exemptions that we're going to go through today. And really the difference is you are paying to get the job done, and it does not matter whether it takes you a minute or it takes you 100 hours in a week, you're going to get the same amount of money. So it's a set salary. You're not getting paid overtime no matter how many hours you work. And while we certainly would encourage you to take meal and rest breaks, usually they're not required under the law. And most, at least for my clients, and Marla can weigh in if it's different for hers, most of my clients do not maintain timesheets for their employees that they believe to be exempt. Now, a lot of times people will call us and say, well, how do I know if somebody is exempt? And that's where we're going to spend our time today. Marla's going to go through it in detail, but here's sort of a few words of caution up front on questions that people sometimes ask that really are irrelevant. So the first one being titles don't matter. So just simply tacking on manager, oh, they're now the marketing manager instead of the marketing coordinator, or giving someone a manager or director title has nothing to do with whether or not that person is exempt under the law. Similarly, just paying them a salary does not make the employee exempt. A lot of times I'll have clients say, well, I don't want to pay them overtime, so I'm going to put them on a salary. I said, well, that's nice, but unfortunately, that's not how it works. Okay, we're going to go through all of the details of under what circumstances somebody is or is not exempt from overtime, and that's what's really important. And those exemptions are very narrowly construed, and unfortunately, there's not a clear answer. There's a lot of gray area and a lot of subjectiveness when it comes to determining whether somebody is exempt, and so that can give rise to problems down the road if you do get audited, if somebody from the state or the feds come in and they take a look at your wage practices and they start questioning whether or not somebody's exempt. So it's important to get it right. And again, if Marla and I can either one ever help you with this, we're happy to do so. But it's really critical that you have everybody classified correctly. Now, something that's always been in effect for California, and this is another difference between the feds and the state of California. California has a minimum monthly salary requirement in addition to all of the other requirements. So the minimum salary requirement for exempt employees in the state of California is they have to be paid at least 2 times minimum wage in a monthly salary. Now, everybody probably knows by now that the minimum wage is going up from $8 to $9 an hour effective July 1st, which is next week. So that also impacts the monthly salary requirement for the minimum monthly salary requirement for exempt employees. So I've done the math, I'll just tell you. So obviously that's $18 an hour if you want to look at an hourly amount. But the monthly salary requirement is now $3,120 per month. And the annual equivalent of that is $37,440, $37,440. So if you have somebody, and let's say you think they're exempt, and we'll assume for the sake of argument that they're classified correctly, but you're only paying them $35,000 a year, that means as of July 1, you need to give them a raise to get them to $37,440 a year. Okay? So I hope that was clear, and everybody had a chance to write down that number. Now, another thing that's going to come into play is discretion and independent judgment. I'm not going to spend much time on this because Marla's going to talk about it, because it is something that's going to impact all 3 of the big exemptions. So I am actually going to skip right over that and turn it right over to Marla, because I know she's going to be spending time talking about discretion and independent judgment.
Thank you, Linda. I just, first of all, welcome everybody. I'm sorry for the loss this morning for the USA. This is a very complex area of the law, and what we're doing today is just giving you a snapshot. We're going to talk about the 3 primary exemptions is what I'm going to talk about. I want everyone to understand that there are several others. Linda's going to touch on a couple of the more common others, but even in addition to that, there are more. There are 2 sets of primary laws that cover this area. As Linda said, the feds, that's the Fair Labor Standards Act, and in California, it's the Labor Code and the wage orders. I would encourage everyone to start with your applicable wage order, always, to determine whether someone's exempt or not, because each wage order has some nuances in it that might be different. There are 12 industry wage orders and 5 occupational orders, and the occupational orders are used when your particular industry is not one of the 12. The laws sometimes are different between the feds and the state, and to decide or determine which one applies, we look at which has the higher standard. And the best example, Linda said, in California, we have overtime requirements for over 8 hours in a day. The federal law does not have that requirement. Since that's a higher standard, that's the one that applies. Okay, so let's jump into the number one, the first exemption. That's really, I always tell clients, this is usually an easy one for you to knock out if you don't have these people. So the first is licensed professionals. So a license in law, practice, medicine, dentistry, optometry, architecture, engineering, teaching, accounting. That's something pretty easy to determine. You either have a license or you don't. And so if you don't, you can knock out this exemption unless it is the second part of the exemption for professional, which is primarily engaged in an occupation commonly recognized as a learned or artistic profession. And I'm going to talk about that on our next slide. But before we do, whether you have the license or the occupation from learned or artistic profession, you have to also have 3, 4, or 5. So 1 gets added to 3, 4, or 5, or 2 gets added to 3, 4, or 5. And 3, 4, or 5 are customarily and regularly exercises discretion, independent judgment, and performance of the above duties. And I will talk to that in another slide, as Linda suggested. Also performs work that is predominantly intellectual and varied in character. So it's not manual, repetitive labor. And as Linda said, earns 2 times the state minimum wage and in a salary. So put salary next to that because it must be paid in salary with some exemptions. So the doctors and lawyers are exempted out of that, and there are some other very, very minor exceptions. So with respect to the learned professionals and the artistic professions, these are individuals who practice in the learned professionals can be individuals who practice in one of the 8 professions that we have the licenses for, but who don't quite yet have their licenses. Recent court decisions have held that they may be exempt, but it's a factually intensive, as you'll see many of these are, analysis. You have to look at the actual job duties and responsibilities. So you might have someone who's about ready for the CPA exam, and with respect to their job duties and responsibilities, they are going to be found exempt, and somebody else who is also about to sit for the CPA exam, but based on what they're doing at their CPA firm, they're not going to be exempt. So you have to look at each one. With respect to the artistic professions, we're talking about people like artists, writers, musicians, that type of thing. And some examples of the learned professions also beyond CPAs and or potential CPAs and potential attorneys is, research chemists, biologists, geologists. The next slide, learned or artistic professions, gives you a little bit more definition on both of these. It requires advanced knowledge in a science or learning field. This is for the learned profession. Customarily acquired by prolonged course of specialized intellectual instruction and study. What this means is it's not high school. It's got to be beyond high school, typically a baccalaureate or beyond that. On the artistic, their second bullet point, it's got to be a profession that's original and creative in character and a recognized field of artistic endeavor, as opposed to work that can be produced by a person endowed with general manual or intellectual ability. And for both of them, it must be predominantly intellectual and varied in character. Again, we're not talking about routine mental, manual, mechanical, or physical work. So if you have someone who's reproducing photographs as opposed to taking photographs, that's not going to count. So the second primary exemption from overtime is, again, what I tell clients, very simple, I think, to determine. And this is the executive, or we call it the managerial exemption. And this is for individual employees who manage 2 or more, and it is 2 or more, not 1, 2 or more employees with the authority to hire, fire, promote, demote. Their primary duty is management of the business, of a department or subdivision, but they have to have the 2 employees. And they have to be 2 or more full-time employees. they have to customarily and regularly exercise discretion and independent judgment, like the other, which we will go over later, another slide. And they have to do this more than 50% of their time, which means 51% or more of their time. It becomes the only difficult factual part of the analysis, in my opinion. Again, the monthly compensation has to be 2 times the state minimum wage, and it has to be paid in a salary. To jump back to the 51% or more of the time, as recently as last September 2013, Taco Bell paid $2.5 million to settle a lawsuit brought by one of their employees who was what they call manager or key manager, someone who had a key to the store and managed well more than 2 or more employees. The problem was they weren't doing it 51% or more of the time. They were selling tacos, busting tables. I pull this example out because this isn't the first time Taco Bell has had to do this. This one happened to be settled. They've had judgments against them for this. As recently as 2001, they had $13 million settlement that they paid. So I bring this to everyone's attention every time I speak on this subject because I just want to show that even the big guys make mistakes because this area is so complex, and sometimes you can't determine factually for certainty, and we, like the independent contractor versus employee classification, we can only give an opinion on what we think. Whether or not this employee is exempt, we can't make the final analysis. Only a court or the DLSE can do that. With the exception of, obviously, the license. You'll know whether someone has a license, but you still have those other parts of the test. So the next slide is some examples of exempt duties and non-exempt duties. You'll see exempt duties include interviewing, selecting, hiring, training employees. This is for the management exemption. Setting and adjusting pay rates, directing work, calendaring, production records, performance evaluations. All these types of things are directed at managing employees. Non-exempt duties, again, for Taco Bell would be selling tacos, busing tables, but here, the general terms, performing the same kind of work as those who are not exempt, whatever that work may be. If you have to get on a manufacturing line, if you have to do accounting, and you may not be doing it alone. I'll give you some examples of that later. The routine work in checking and inspecting goods, those types of things that non-exempt employees are doing. Next slide. Some other considerations for this is emergencies. Managers will not lose an exemption if emergency comes up. For example, a retail store and an employee doesn't show up and the manager has to get out on the floor and start selling. Because of that emergency, they're not going to lose the exemption because they were doing non-exempt work. Trainees, employees in training for employment as an executive or an exempt profession are not exempt unless they're actually performing the duties of the exempt job on a regular basis. So that's a difficult analysis. You have to look at how often they're doing it. And again, we've said this earlier, but the requirement of the state and federal exemptions often vary. So we have to look at both, and then whichever is more protective of the employee or provides the higher standard, that will prevail. On the next slide, this is just an example of 2 activities that an employee might be engaged in, and it doesn't take away their exemption when they might be engaging in 2 activities. The first one is a manager who's working on a word processor to draft a document. Now, clearly, word processing by itself doesn't require independent judgment and doesn't necessarily get to the level of an exemption, but the drafting of the document may. And the second is the example I gave earlier about a sales manager who has to send some of the sales staff off to lunch, and so the manager has to get on the floor, start working the sales. That the exempt activities are not going to be precluded because they engaged in non-exempt work. And the third primary exemption, which is the most difficult one, is the administrative exemption. And I often have clients who think everybody falls into this category, and the opposite is true. Most people do not fall into this category. It's a very high standard. The courts have even told us that they're holding it to a high standard. I'm going to give you some of the court's language. We had hoped back in 2012 that the California Supreme Court was going to give us more direction on this. They gave us very limited, but we'll talk about it. But here the primary duty is the performance of office or non-manual work directly related, and I'd say underline that, to management policies or the general business operations of the employer or the employer's customers. Or the second prong, and you'll see that most of these have second prongs, the performance of functions in the administration of a school system or educational establishment or institution. Now that's very limited in scope, so we're going to concentrate on bullet point 1. And both of these, of course, have to have the ands, as did the others. Customarily and regularly exercises discretion and independent judgment. So I said we were going to speak about that. We'll do it now. What is that? Those are words like reasonableness. Customarily, we know, means often. Regularly, often. Discretion and independent judgment. What the courts have said is this means ask these questions. Does the employee have authority to formulate, affect, interpret, or implement managerial policies? Does the employee have that same authority to implement, formulate, affect, interpret operating practices? It implies that the employee has that authority if they can make independent choices free from direction or supervision of matters of significance. So let me give you an example where that's not the case. I worked for an employer who wanted the accounting professional who worked in our firm to be exempt from overtime under this exemption, and it just couldn't happen. This person did all the billing, all the accounts payable, all the accounts receivable, but it had no ability to make any decisions regarding the company's policies or the company's operations on their own. There were no decisions about what would be paid, what wouldn't be paid, when it would be paid, when it wouldn't be paid. Should we increase our line of credit, decrease our line of credit? Everything was done with supervision. So if everything's done with supervision and instruction, you're not going to have that independence. So that's something to look at. Another example is secretaries, administrative staff. If they don't have the ability to make these very important, significant decisions, then they're not going to fall under this exemption because they're not going to have that independent judgment. HR managers very often do fall under this exemption because they are given that independence. However, I've worked with many HR managers who are not. They don't have the ability to make decisions on their own. Every decision has to be supervised. Purchasing agents is another example where we do sometimes see this exemption. So the others are as they were before, devote more than 50% of the time and at least 2 times minimum wage paid for in a salary. Bullet 4, let me just direct your attention there for just a moment. Regularly and directly assist a proprietor. A proprietor, for those who don't know, is an owner. So the principals or owners, or I would also include in that the top-level management executives of the company. And again, this can be for the employer or the employer's customers. On the next slide, there's some examples of administrative duties. For the exempt, it's advising management, planning, negotiating, clearly someone who's going to be involved in strategic planning meetings of the company, representing the company outside the company, purchasing materials and supplies, promoting sales. But again, if they're doing this at someone's direction, if someone else is telling them what to buy, what to purchase as far as materials and sales and supplies, it's not going to apply. Determining company and or personnel policies. That's the critical thing, along with the independence. Non-exempt duties, again, are routine and clerical, deliveries, operating equipment, inspecting products, tabulating data. Goes back to my example of the accountant. Where we see exempt administrative people is in tax areas, research, marketing, legal compliance, consulting, with consultants for customers. The next slide has some examples of administrative employees who may, and I underline may, qualify as exempt because we're only giving you a couple of facts, but executive or administrative assistants who have delegated part of their where the executive has delegated part of their discretionary powers. That, again, is they have to have that independence to make those important decisions. Staff employees who are functional rather than department heads. This could include employees who act as advisory specialists to management or the employer's customers. Typical examples, again, are tax experts, insurance experts, sales research experts, some of the others I gave you on the earlier slide. And the third is employees who perform special assignments under only general supervision. There's that independence again. As I said, back in 2012, we expected the Supreme Court to give us some clarification. For those of you who like to pull cases and cites, it was Harris versus Superior Court. And here's what we got. court said that we have to require a two-pronged analysis, a qualitative analysis and a quantitative analysis. The qualitative analysis requires that we determine whether the work is administrative in nature, such as advising management, planning, negotiating, and representing the company. Those are the court's terms. So we make that analysis first, and then we have to do the quantitative analysis, and that was determine whether the work is of substantial, again, the court's terms, substantial importance to management policy or general business operations. So by way of example, I don't think it's a substantial importance to determine what kind of coffee we're going to put in the break room, but it is of substantial importance to determine what are our work hours. That's an example of a policy that is very substantial to both management and business operations. So with that, I'm going to turn it over to Linda.
Thanks, Marla. Great job, and thanks so much for, I don't know, I was going to say clarifying, but I don't know that there's always clarity at the end of these discussions at all. All right, so there's a couple other exemptions that we talked about in addition to what I referred to as big three that Marla just covered. One is for salespeople. Two different types of salespeople. We're going to talk about outside sales and inside sales. Outside sales is fairly clear that their outside salesperson is exempt from overtime and also minimum wage for that matter if they're 18 years of age or older and they spend more than 50% of their time away from the employer's place of business doing sales. Now, that also, when you see employer's place of business, they cannot work out of their home and meet that qualification. They would have to be away from their home if that is where they're assigned to work. So you may have outside salespeople scattered throughout the country, as I have in the past. What they're talking about is outside sales is somebody who is traveling to customer sites more than 50% of the time, going and meeting with prospective clients, is out doing whatever they're doing outside of the employer's place of business or their home if they're home-based. Now, inside sales is a little bit different. Inside sales actually has a different requirement that goes with it. For inside sales, and unfortunately I will tell you, in my whole career I lost one claim one time for the Department, or not Department of Labor, the Labor Commissioner here in California, and it was on this very issue. For inside sales folks to be exempt from overtime, more than half of their compensation has to come from commissions. They have to have certain amount of money at risk. So we had a situation where we were doing very highly technical sales. I had an employee whose total comp was over $120,000 a year, but the base was $65K. And so she brought a claim, said, I'm not really supposed to be exempt. We had to go back and compensate her because, of course, she was keeping tabs on every time she had a lunch and learn or didn't take a meal or something like that. So here's a situation with an employee making about $120,000 a year, but because her base salary was more than half and her commission was less than half, she was considered non-exempt, and we had to go back and actually go back and calculate overtime for all of those pay periods and come up with money to pay her for that. So for inside sales, what you need to make sure of is, again, their commission is more than half of their compensation. And if you have weeks where the person, or months, or however it is, where the person does not make enough commission, you have to go back and calculate overtime for that pay period and pay them the overtime. The other one is computer professional exemption. So this was one it came about in the last 10 years or so where people really focused on this. Computer professionals under certain circumstances, again, can be exempt. This is one where I see a lot of confusion, however, because a lot of clients have an IT manager or a webmaster or people, we'll call them computer engineers or software developers or whatever. So I don't need to read this slide to you, but it sort of ties back to some of the comments Marla made before. They have to be engaged in work that's intellectual or creative, work that requires exercise of discretion, independent judgment, and then there's three different types of work that can be done. And again, you'll see by all of the verbs there, it's really matters of importance, matters where they have some either expertise or they're doing something that's more creative in nature, where they're actually doing coding or they're doing something. It's not a help desk technician, as an example. It's not someone that's going to go fix your hardware. That's more of a technical skill. So this is this is more of an intellectual type of skills that probably requires some advanced knowledge. The other thing about computer professional, they actually have a higher salary standard than the other exemptions do. So the rate of pay for a computer professional has to be the equivalent of $84,130.56 per year. So I just updated that for 2014. So that's the other area to note. So you may have somebody you think meets all the qualifications from the prior slide, but if you're not paying that person over the $84,000 number, you cannot have them as exempt. All right. We talked briefly before about the liability for noncompliance. And again, as Marla said, the problem with this and why this is so subjective, or why it's so important, is because it is subjective. We could come in and do analysis as we've done for our clients. This always gives me a little bit of pause, and I'm sure it does Marla, because we can use our best judgment. We can study the position. We can figure out whether or not the primary duties are exempt in more than 51% of the time. But as we all know, jobs change. We know that no job is usually the same from day to day if it's going to be exempt. And then somebody could come in from the DLSE or DOL or somebody else to take a look at it and go, nope, you know what, we don't think it is exempt, and here's why. It's subject to interpretation, and there's so much gray area, like Marla said, about what constitutes, discretion, independent judgment, things like that. So you want to be as careful as possible. There are some that are clearer cut than others. So just make sure that you take the time to do the analysis and that you document whatever it was that you saw in terms of behavior, or you have time records of how they're spending their time, whatever it is you have to do, but make sure that you are creating some records so if somebody does challenge it, you can fight your battle. So let's talk about what to do under these two scenarios, because these happen from time to time where maybe you have a non-exempt employer, someone you can pay on an hourly basis, and you say, you know what, I want to take a look to see if they may actually be exempt. Maybe you're promoting somebody from non-exempt to exempt. It could come up for different reasons. And what you want to do is obviously, again, do the analysis to make sure the person is going to qualify as an exempt employee by documenting those essential job functions and everything. But just from a practical standpoint, if someone's going from non-exempt to exempt, what's the likelihood that they're going to be really happy if you don't include their overtime or the previous overtime in picking a salary for them? That's sort of a no-brainer to me, but I've had people just say, well, I'm just going to take the hourly rate we were paying them, multiplied by 2,080 hours, and then that's going to be their salary. When in essence, if you look at their W-2 from the year before, maybe you're going to make them salaried at $50,000, but last year they actually made $60,000 or $65,000 because they're working overtime. So you want to make sure you take that into consideration when you're setting that salary. And for both directions, whether you're changing them from non-exempt to exempt or exempt to non-exempt, you always want to take a look at what other benefits and policies are affected. Certainly the timekeeping policy is going to be one. It may actually impact their pay schedule. I've got clients who pay non-exempt, and in this case hourly employees on a weekly basis, but they may pay their exempt employees semi-monthly. So that's going to impact people as well. You can have a social media policy that prohibits non-exempt employees from, posting anything or using company equipment to look at different social media sites after hours, and maybe exempt employees are allowed to do that. So there's ways that people differentiate between them, not just in terms of how they pay them, but in terms of benefits and other policies. You want to take a look at all of those. Now, the harder change, in my opinion anyway, is changing people who have been salaried exempt to a non-exempt category. One of the reasons it's difficult is there's different ways this can happen. Maybe the role has changed as of right now, and you're going to change them going forward. But let's say you do call me up, you bring me in, I do the analysis, and then I come to you and I say, you know what, you've got this position, let's call it a sales analyst. You've got this position, you've been paying them salary exempt. I do the analysis and I say, you know what, I don't think this position's exempt, and here's why. I think it's really non-exempt. And then we sit down and talk about it, and the person in that role has been in that role for 3 or 4 years, and they've been working a lot of overtime, but you haven't been compensating for that. The question is, what do you do about that? Do you go back? Do you try to figure out how much time they've worked? Because in the example of the inside salesperson that I talked about before, we had her classified improperly, obviously, as exempt. She wasn't keeping any formal time-keeping records for the company. She wasn't clocking in and out. She wasn't on a timesheet. She, of course, went back and tried to put together all the time she had worked overtime, missed a meal, anything like that. So you can go back and try to estimate if you want to. You can also just change it and go forward and keep your fingers crossed and hold your breath and hope that no one, ever files a claim. What do you do about former employees? Maybe you take a look at this inside salesperson or sales analyst or whatever, and you say, you know what, we realized that we should have had this person be non-exempt and should have been paid for the overtime, so we're going to fix it with our current employees as we did when I was with that company. But what about the employee that worked there in that role until last month and they're gone? Do you want to go back and pay them, or do you want to, again, roll the dice and see if they're going to bring a claim? So that's what gets a little bit confusing about how to make those changes. I would say I'd love to give you a quick answer on how to do it, but I will tell you each client of mine where this has come up, we take a look on a case-by-case basis. We take a look at the facts, what we think the potential liability is, how easy it is for us or for the employee or us, together to estimate how many overtime hours they work, all sorts of different things. The one thing I will say, which is sort of an interesting point anyway, is that typically in California you cannot have an employee waive a wage claim, but one of the exceptions to that rule is if the amount that you owe them or if their status or anything like that is in dispute, then you can actually settle that potential wage claim. So that comes up, and oftentimes this is what we do. We'll take a look and we'll say, okay, well, you know what, nobody has records of how many overtime hours were worked. I'll use that salesperson example again. She estimated it. We had her supervisor look at it. We said, what do you think it is? In that case, we were before the Labor Commissioner, but for the rest of the employees, we asked everybody to estimate what they thought they worked in terms of overtime. We asked the manager to review it and sign off on it, and then we went to the employee and we made them an offer, essentially. We took a look at what it would be if that number was exactly right, but I'm telling you that you don't necessarily have to do all the math out and then come up with that number. You can say, you know what, it's somewhere between this and this, and go to the employee and say, look, this is our offer to try to settle this dispute. Marla can provide you with a settlement agreement, and then that's something that you can use so you don't have that liability or potential liability hanging over your head. Okay, we're going to go through a few of the common questions that Marla and I see on this topic, and then we will open it up to your questions after that. So the first one is the work my employee does is really important. Is the employee exempt? And you probably determined by now the work, just because it's of value or important to the company, does not really factor in whether or not the employee is exempt. So I will give you an example. I would like to believe that airline inspector at Boeing work is very valuable to me because I'm going to get on a plane on Saturday, and I would think that that is a really critical function. But doing the inspection on airplane is not going to meet any of the standards that Marla and I have already talked about. So that person would be non-exempt in the law. So again, it's important work. No one's saying it's not important, but that does not make the employee exempt. Sort of the same thing with the important decisions. Is the person exempt? It really depends on what type of decisions are being made. So if they have decision-making authority to hire and to fire, to promote, demote, all of those things, then perhaps, right? Depends on how much time they spend doing that. So again, there's no really one little question you can ask to see if somebody is exempt. You have to take a look at all of those rules for each exemption and go through them and see if in totality it makes sense to have that employee be exempt. I want to reward an employee by making him or her exempt. Can I do that? No. Similarly, I'll just tell you right now, number 7 says my employee asked to be placed on a salary. Can they sign a waiver? No, because again, it's not really up to you guys. You cannot just enter into agreement because one of you wants to pay a salary or receive a salary to say, oh, you're going to be exempt from overtime. You have to go through all of the standards and make sure that the position itself gives rise to that exemption. Question number 4, what if an employee is doing both non-exempt and exempt work? So again, the position must spend at least 51% of the time during the work week actually performing exempt level work. So yes, some of the work may be exempt, some may be non-exempt, but overall you have to meet all of those standards, starting with the exempt level work has to be, and the primary duty has to be at least the 51%. If somebody has a blended role, so like sales is 50% of their time and purchasing 50% of the time, could you be exempt for half of your day and then non-exempt for the other half? And the answer is no. They take a look at the total role this person has, and this could easily happen, especially in some of my smaller clients where they wear multiple hats. So some of their role may very well be exempt, but when you look at their entire work week and all of their duties for that position, whatever it's called, again, you have to meet all of those standards for one of those exemptions that Marla went through before. And then what if my employee performs some managerial work and some administrative work? Can I combine exempt work? So combining exempt work, or what they call packing together, yes, it is possible. So again, you take a look at where they're spending their time, what the duties are, what are exempt, what are non-exempt, add them all up, make sure you're going to meet the 51% threshold, and that the rest of the rules you're in compliance with as well with regard to minimum salary and all the rest of it. Okay, I think we're right on time, Julie. I'm going to turn it back over to you so you can ask questions.
Great. Thank you very much, Marla and Linda, for helping us to better understand employee classification. I'm always mystified every time I listen to these that, how complex this actually is. So, and I'm sure all of you have questions just like I do. So that concludes the presentation portion, and now what we're going to do is open it up for questions. And how we do that is there's a question box that's actually on your dashboard. All you do is open that up. There's a blank spot below. Type in your question, hit submit, and then I will be able to read that aloud for Marla or Linda to answer. So let's get started here first. Maggie's got a question. For an administrative exemption, what happens when your job description says that you are supposed to be able to have independent judgment, but in fact you do not?
Oh, that's a great question. The job description is not going to be determinative. It's going to be what you're actually doing. And that's a fantastic question, because employers do try to get around this by putting into the job. I've seen many job descriptions written where they've just taken this exact language that you have in the handout, which comes from the wage orders, which is where I've, back to the beginning, asked everyone to start, and they just pull it out and say, this is your job description. But if that's not what the employee is actually doing, then no, it's not. You're not going to meet the exempt test.
Okay, good. Thank you. Linda, did you have anything to add?
Nope, I will just say ditto.
Okay, great. And then Jill has a question about the typical computer professional. Can you go through a little bit more in detail and maybe give Jill some examples of some of those computer professional exempt roles, like what the typical ones are?
Yeah, let me see if I can go back to that slide for you. I don't know.
Okay. Can you? Here.
Hold on. Yeah, let me see if I can get back again. So yeah, I'm trying to think of some examples. So certainly anybody that, like I mentioned before, anybody that's doing help desk type work, even, like managing servers or doing anything like that, where maybe they're installing software, they're managing the software, is probably not going to give rise to an exempt status, and you may or may not be paying them, again, the $84,000 you have to pay them during the year. So let's look at the 1, 2, and 3 sub numbers to item number 1. So applying systems analysis, right? Consulting with users, determining hardware, software, system functional specs. So that's a higher level job than rolling out the software, or maybe you've got 50 users in your group and I have to go around and put Microsoft Outlook on all the different systems. That's not exempt level work. Me going around to the 50 users, showing them how to use it, or fixing their desktop or laptops when they break, that's not going to give rise to exempt level. But if I am consulting internally or externally with clients perhaps on what's the best software to use, if I am managing the project to change from one software ERP package to another, that might be an example. designing, developing, documenting, analyzing, creating, testing, modifying computer systems or programs. Again, it's really about the level of work. So another example that came up recently for me was doing this analysis actually at a company, and we were looking at people in their IT department, and in their particular company, they have webmasters. They have more than one actually. Well, they are a consumer-facing organization that uses their website. They have an employee portal that can go in for different things. They have a customer portal. They have a supplier portal. And the webmaster was actually not just taking other people's content and then updating like my webmaster would do for my website. I would say, hey, you know, I want to change out the picture on this page, or Julie just wrote me this great copy for my recruiting page. Can you go update it? That is not exempt level work, right? But in this case of this client, they're actually, you know, developing systems that help the business run better. That's a very different type of level of work than just taking somebody else's content and throwing it up on the screen and making it look pretty. So I don't know if those examples help, but hopefully that'll give you an idea of how to draw some distinctions.
Okay, good. And Jill, again, feel free to email Linda or Marla, you know, afterward too, if you have more specific questions or have a specific example in mind. Lily,
Julie, can I interrupt for just a minute? I can give some example job titles in this area that have been held to be exempt, that I would just qualify that with what Linda said at the very beginning of the program. A title alone does not make you exempt, nor does it, as Maggie asked, a job description. But some of the common job titles where we see this exemption is computer programmer, systems analyst, applications programmer, a systems engineer. These are highly skilled employees. Remember, they still have to be working independently and without close supervision, so they're generally very educated with lots of experience.
Okay, good. Thank you. Let's see here. We're going to go back to the questions here just a second. We've got an example. Oh, here. Lily, when can you apply sick and vacation time to a salaried employee's work week?
Okay, I'll take this one.
All right.
Up until 2009, I'd say never. But in 2009, we did get clarification from the Division of Labor Standards and Enforcement and an advice letter that says we're going to follow the federal rules and we're going to allow you to do this even for a partial day's work off of an exempt employees. Now, that's a advice letter from the DLSE. It's just an opinion. The courts generally do follow the DLSE's opinions, but they're not required to, and we don't have any court decisions on it. So for my client employers that are risk adverse and don't want any risk, I said don't do it at all, unless it's a scheduled vacation or a request by the employee. For those who are willing to rely on these advice and opinion letters, you can do it for partial days or for full days.
Okay, good.
So let me jump on that. So here's what the tricky part is you can, like, let's say you have a PTO policy that says, hey, if somebody's out sick or wants a personal day to take on vacation, we're going to charge you to their PTO. And let's say you give that person 80 hours a year. But they've exhausted it. Now what do you do? And the answer is you do not deduct from their salary. So you can deduct as long as there is a balance from which to deduct, but once they've exhausted it, if they work any time during the week, you're paying their full salary. So that's what's confusing about the exempt deductions. And I didn't catch who asked the question, but I do have like a memo I've written on that for my clients. I'm happy to share it if you email me.
Okay, Lily, that you can just email directly to Linda, and she'll be happy to share that with you. Judy also has a question. Do both non-exempt and exempt employees need to turn in timesheets?
Well, that's a philosophical question. Exempt employees, under the law, exempt employees are not required to keep timesheets. However, as you can see from all of this complexity that we've been discussing today, you may have classified someone improperly as exempt, and where that becomes a problem is when they do bring a wage claim, generally an overtime claim, and they come in and they bring their own time records, and you as the employer have no time records. If they are found to be non-exempt, the burden then shifts to the employer to give time records, because the law requires you to have time records even if you've improperly classified them. And if you don't have them, whatever the employee puts in front of the decider of fact, whether it's a deputy at the DLSE or a judge or a jury, they're deemed to be true unless you can prove them otherwise. And it's very difficult to do that. Sometimes we're able to do it with computer, clock in and clock out, or security camera clock in and clock out. We can show that that person didn't work from 8 a.m. to 8 p.m. every day, because that's the way these calendars and time records from the employees look. I cannot tell you how many times we've received a wage claim with calendar and time records attached where the employee swears for the last 3 years every single day that they worked 8 a.m. to 8 p.m. And it's okay for them to say that, and it's going to be deemed to be true if you don't have records. So some employers require all employees, including exempt employees, to keep records just in case the classification as exempt is incorrect. And also sometimes for other purposes, particularly if you work for an employer where they want to analyze the cost of certain jobs, how many hours of employee work it goes to complete a project. So by law, no, you don't have to keep the time records, but by choice, sometimes employers do.
Okay, great. Deborah has a question. Can you give me an example of an employee who is salaried non-exempt who earns overtime?
I can. I have one. I have one. My litigation secretary here at our firm is salary, only because the term salary sounds professional, and we're a professional office, and people who work in law firms hold themselves out as professional, and the term hourly sounds non-professional. However, she's not exempt under any of the tests. So if she works overtime, we have to break her salary down to an hourly wage, and we have to pay her overtime. Linda came up with a very clever term today that I had not heard before that I really liked in this regard. What was it this morning, Linda?
Salaried overtime eligible.
I love it. I absolutely love it. I prefer that my clients not pay someone who's not exempt salary, because then they get confused. It's much easier to remember. Yeah. Anybody who's hourly, you better pay them overtime. But in some cases, like mine, it would be highly offensive to tell a professional person that they're paid hourly.
Yes. Well, and let me weigh in on this one, because I will argue this point with my clients all day long. I think it's very confusing also. I do not like salary non-exempt as a classification personally. I think, and that's why I think it's the good news, bad news. A lot of people equate hourly to non-exempt and then salaried to exempt. I sort of like it that way, even though they're not using the right terms all the time, because I think in most employers, salaried non-exempt is the best of both worlds for the employee. It's not friendly to a business owner, because essentially for the reason that the previous person asked the question about deductions. So I'm going to get paid 100% of my salary regardless of how many hours I work, because that's a salary. But if I work overtime, I also get overtime pay. And so I just don't really understand the benefit to the employer. So in Marla's case, it's more of an ego thing for her employees, and maybe how it appears to the outside world if they ever knew. But for my clients, I highly, highly recommend that they use one or the other, but not salaried non-exempt, or the phrase of the week, salaried overtime eligible.
Good, thank you. We have a couple questions on vacation sick days, and I'm going to start with Crystal. I have an exempt staff. He does not have enough sick personal hours. Can I deduct his pay with his authorization?
No. I was going to say, in a word, go ahead, Linda.
No, I was going to say, in a word, no. Again, if you're paying somebody on a salary, there are very few exceptions to that. The week somebody starts, the week somebody ends, you can prorate their week, subject to a bona fide, PTO, vacation, or sick plan. But once they exhaust the time that they've accrued and they're out again, you can discipline them, but you cannot make the deduction if they've worked it all. If they're gone for the entire week, you could. But if they've worked it all during the week, and who doesn't work from home,
right,
or check their email on their smartphone or whatever it is.
Okay, Marla, did you have something?
Yeah, I just wanted to add, that this is an area you got to be really careful with, because if you improperly deduct from an exempt employee, you may have converted them to a non-exempt employee. and then you obviously subject to all those overtime claims. This is a pet peeve area of mine, this whole subject area. There is a federal exemption that we don't have here in California. For any of you who have friends who are legislators, maybe you can write to them and ask them to change our laws. There's a federal exemption that says if you're paid $100,000 a year or more and you engage in exempt activities, you're exempt. It doesn't matter. That's such a high number that we don't care how many hours you work a week. You make enough money. I really like to see California adopt some line. I don't care what the number is, pick a number, but it would be nice for employers to have some guidance where we know if we pay at least this and there's at least some exempt activity being performed, then the person's exempt. When you start deducting from exempt employees, you might go below that 2 times minimum wage, especially now that our minimum wage is climbing. So it's a very tricky area.
Okay, good. Sarah has...
I'll get off my soapbox.
Yeah, I can always tell when you're really passionate about something.
I am.
Sarah's got a question. I'm currently doing an exemption, non-exempt review right now on many positions in her company, and I have several situations where the employee has to problem solve or use discretion to figure out or troubleshoot situations. This seems to fall under the learned professional exemption, but these individuals are not licensed professionals. How much freedom does the learned professional criteria allow for this type of exemption?
Well, the learned professional, remember, it's got to be somebody who's got advanced education in that area. This is not, it's not just, you know, a problem solver. It's got to be somebody who's got advanced education in whatever area they're performing in.
Okay. All right. Good. All right.
I would say I've got to, again, go ahead.
No, I'm sorry. I thought you were done. I was going to say, you know, look at all of the exemptions, though, right? So it depends on what type of job it is. So I didn't hear you say the type of position, so I don't know if they're talking about, you know, an engineer or, you know, somebody else. But if it doesn't qualify under like a professional exemption, what about under administrative one? It depends on the types of problems they're solving, how, you know, of what importance to the employer the types of problems are, or to the clients, or whatever.
Okay, good. And we have time, it looks like, for one more question from Roy. And he's asking, can a help desk senior technician with applications experience be exempt?
It doesn't matter what their experience is, it matters what their job entails. And I would say, generally speaking, help desk, probably not.
Okay. All right, good. And again, unfortunately, I know we have several questions here left. Let me just handle some in the macro sense. We do have not only the presentation available, you can certainly email me now, julie@thedoorgroup.com, and I would be happy to send that to you. I know many of you have been asking during the course of the webinar, and I've been sending that out. So feel free again to email me so that you can get that presentation and then, of course, all this valuable information here. Also, we are looking at webinars for the rest of the year. We've got one coming up again, which I think actually applies to some of the things we discussed today. On 7/16, misclassifying 1099s, independent contractors as employees. So that one is going to be good, and another one that kind of keeps you out of the hot water. And then the schedule here also, there's a great one coming up on immigration and then drug testing in October. So you've got the schedule if you've got the handout. And then also just on behalf of Linda Duffy with Ethos Human Capital Solutions and Marla Merhab Robinson with Merhab Robinson, Jackson, and Clarkson, I'd like to thank you for joining us today. Feel free to contact Marla and Linda with any questions that you might have. That would be, again, here's their email addresses, but again, also in your handouts. Sign up. The registration for the next webinar, which is misclassifying independent contractors as employees, is right here, so just click on that and register. We get filled up. We had a big group on today, so make sure that you get your registration in so we have enough space for you. And that should do it today. Again, sorry about the U.S. soccer team, but we do appreciate your time today and look forward to providing you with more useful information in the form of these webinars later on. So have a good rest of the day. Thank you.